So we are back again and we take chapter 5 of company law. My name is kimanzi of Fatma Training Institute, Center for CIFA Studies. We are based in Bika Town. My numbers are 0727 871093. Chapter 5 is about share capital. Share capital is our topic for today, and we will be covering meaning and types of share capital, the raising of share capital, prospectus, as well as information memorandum, the maintenance of capital, alteration and consolidation of share capital, and then lastly, we'll take dividends. So, as our custom, I just show you what we'll be going through as far as chapter 5 is concerned. This is what you are expected to go through. Chapter 5 of company law is about share capital. You take meaning and types of share capital, raising of share capital, prospectus and information memorandum, maintenance of capital, alteration and consolidation of share capital, the dividends. That is what we are taking today. Now, we define a share as a unit of capital. Usually, companies raise capital through issue of shares. As far as types of business is concerned, we've done sole traders, we've done partnerships, cooperative societies, as well as companies. Whereas sole traders may raise their capital from different sources, such as from loans, from friends, from savings. Companies, most of the times, will raise their capital from shares. In chapter 4, we did types of shares where we discussed preference shares, ordinary shares, deferred shares, and employees shares that we have done in chapter 4. Now here, we are taking share capital, and we say that a share means unit of capital. So shares, we usually take the capital which the company wishes to raise, and then we divide them into units, and each unit of capital is known as a share. Like for example, if you have share capital of 1,000 shillings and you divide them by 100, then you have each unit being allocated 10 shillings. So each share with 10 shillings, or maybe you are saying you have 10 shares of a certain figure or of a certain worth. Okay, we've defined share. Here you say the share means a unit of capital. Share means a unit of capital. For instance, a company may have shillings 100,000 shares divided into 1,000 units, each with a par value of shillings 10. That's what a share is. Now from there we have types of share capital, and one is what we call nominal. You have nominal or registered share capital. One type of share is known as nominal. Now, first, I should show you these types of shares. Just go through these types of shares. As we discuss them, you discuss nominal or registered share capital. After that, you take issued share capital, then unissued share capital, called up capital, uncalled up capital, paid up capital, and unpaid up capital. So those are the types of shares. You can pause your video and you read their meaning. You can pause your video and you go through types of share capital. Pause your video, read the meaning of these types of share capital as I discuss them. Nominal share capital, also known as registered share capital. A nominal or registered share capital, this is also called the authorized share capital. It is amount contained in the nominal capital clause in a memorandum of association, the maximum of which the company cannot exceed. If the nominal capital, for example, is 100,000 shares, then the company cannot raise more than 100,000 shares from the members in the form of shares. So we are saying that nominal share capital or registered share capital or authorized share capital is that amount beyond which we cannot exceed as far as a company the raising of capital is concerned. You find it in the memorandum of association. Since we have done the constitutive documents and we know what you find in the memorandum of association, in the capital clause, it provides the maximum amount of capital that we cannot exceed. If in the memorandum of association, the capital clause is 100 million, then we cannot exceed 100 million in terms of the limit now beyond which we cannot exceed. So that's the nominal or registered share capital, also known as authorized share capital. That maximum beyond which we cannot exceed. If our nominal capital is 10 million shares, then the maximum that we can raise is the equivalent of 10 million. That is it. Number two was issued share capital. So once we have our registered share capital or the nominal share capital, then the next thing is now issuing these shares to the members of the public so that the subscribers or the members will give us money and we give them shares. They become shareholders. So out of that arrangement, because the investors have invested in our company, we have their resources. They are shareholders. We will be, as a company, be paying them dividends as either interim dividends or final dividends. So that's the issued share capital. That amount or the shares that we have issued to the members of the public for the sake of subscription. So issued share capital is that part of the nominal capital which the company has issued to the members of the public for subscription. If my registered share capital or nominal capital is 1,000 shares, for example, out of the 1,000 shares, which is the nominal or registered share capital, basically I cannot raise capital above the maximum. But out of that, there is that portion now which I will issue to the members of the public for subscription. And that portion which I have issued to the members of the public for subscription is known as issued share capital. So issued share capital is that part of the nominal capital which the company has issued to the members of the public for subscription. Number next is unissued share capital. Unissued. So if there is that portion which you have issued to the members of the public, definitely there is that part which we have not issued. So that qualifies to be called unissued share capital. Unissued share capital. That portion of the nominal capital which the shareholders have not taken up. The shareholders have not taken up. So that portion which has been issued is the issued share capital. What remains is the unissued share capital. Next is called up capital. Called up capital, that portion of issued capital which shareholders have been called upon to pay in respect of the shares held. Last lesson we discussed about calls of shares and forfeiture of shares. A call is made where shares are being issued and the payments are being made by installments. So where there is a certain portion which is in arrears and has not been paid for, a call is a reminder to the subscriber to pay for the shares which are in arrears, the payment which has not been made. So here we are saying called up capital is that portion of issued capital which shareholders have been called upon to pay in respect of the shares held. So for called up is coming out of issued capital. So we issue the capital to the members of the public. However, there is a certain portion which has not been paid for. There is a certain portion which has not been paid for. That's a called up capital. Then uncalled up capital. That portion, if any, of the issued share capital for which members are still liable. It is a subject matter of the calls made on shares, so uncalled up capital. Then paid up capital. This is the portion of the issued capital which the shareholders have paid for, and the company has received the payment as a paid up capital. So we issue the shares, and then the subscribers have paid for these shares, and the company has received the cash with respect to these particular shares. That becomes a paid up capital. And lastly, unpaid up capital. This is the portion of the issued capital which is still outstanding and the members are still liable. So that is the meaning and types of share capital. We have defined what a share is. A share is a unit of capital. Share is a unit of capital. And then types of share capital, we have nominal, also known as registered share capital, also known as authorized share capital. Number 2, we have issued share capital. Number 3, unissued share capital. Number 4, called up capital. Next, uncalled up capital. Next is paid up capital. And the last one is unpaid up capital. So before we move to the next part now, we just go through that. If you didn't get it correct, you can check the meaning of share, what a share is. You can take what a share is. You can look at share, the meaning of a share. Share means a unit of capital. Then types of share capital, you can look at nominal, or registered share capital, or authorized share capital. Then we have issued share capital, unissued share capital, called up capital, uncalled up capital, paid up capital, and unpaid up capital. You can check my numbers down here. Okay, out of that now, we will move to the next thing, and that is raising, raising of, raising of share capital. How do we raise? How do we raise share capital? How do we raise share capital? So this can either be direct offers or invitation to the public or prospectus issue, offers for sale, placing, offer by tender, rights issue, and bonus issue. So these are the ways that you have how to raising of share capital. Raising of share capital. So raising of share capital is done through flotation. So flotation means the process of raising share capital. So flotation is a process in which companies avail securities to the public for subscription. It helps the company to raise capital from the public. Flotation may take the following form. So we are saying the process in which companies raise capital from the members of the public is known as flotation. And flotation may take 6 major forms, one being direct offers, also known as invitation to the public, also known as prospectus issue. Can also be offers for sale, placing, offer by tender, rights issue, and bonus issue. The last two we discussed last time, that is rights issue. We define rights issue as the issue of shares to the existing shareholders at a price below the prevailing market price. Bonus issue, we say, is the issue of shares to the existing shareholders for free. The difference here being, for bonus issue, the company does not raise additional funds, whereas for rights issue, there is some funds or some cash received, because for rights issue, we are issuing the shares that are priced below the prevailing market price. I told you to differentiate between issue of shares at a discount and issue of shares that's a rights issue. I emphasize on that issue of shares at a discount arises where the issue is made at a price below the par value, whereas rights issue is the issue of shares at a price below the prevailing market price. Well, let's look at the flotation, the forms of flotation. One, starting with direct offers, which has other alternative names. That is invitation to the public or prospectus issue. This is where the company issues the shares directly to the public rather than issuing them to intermediaries. So a company wishes to raise capital and then it issues the shares directly to the members of the public. In other words, the company is telling the prospective investors to come directly to the company and purchase these shares. So there are no intermediaries, there are no brokers. So you are coming directly to the company, you purchase the shares. That's direct offer, also known as invitation to the public, also known as prospectus issue. So it's where the company issues the shares directly to the public rather than issuing them through intermediaries. Then next is offers for sale. Offers for sale is the other form of flotation. Offers for sale. This is an arrangement whereby a company sells the whole of its shares to an issuing house, and the issuing house then resells the shares to the general public, usually at a profit. So see the difference there. Offers for sale. An issuing house comes in between. So the company is not selling the shares directly to the members of the public, as is the case with direct offer. With the offers for sale, what comes in is the issuing house. So the company will sell the shares to the issuing house, and then the issuing house will sell the shares now to the members of the public, however, at a profit. So in this case, we have an intermediary known as the issuing house. So offers for sale is the other type of rotation. That is an arrangement whereby a company sells the whole of its shares to an issuing house, and the issuing house then resells the shares to the general public, usually at a profit. Next is placing. Placing is the other type of rotation. Placing occurs if the company, instead of selling its shares directly to the public, arranges with a broker to sell them on its behalf. So placing, you have a broker coming in between. See, with the offers for sale, what you have is the issuing house coming in between. With the placing, you have a broker coming in between as an intermediary. So placing occurs if the company, instead of selling its shares directly to the public, arranges with a broker to sell them on its behalf. Next is offer by tender. Now, whenever you see a tender, you have to have in mind the highest bidder. You have several people doing the bidding, and the highest bidder, the highest bidder, the highest bidder is the one to get the sale or to make the purchase. So where you have offer by tender, you should have bidding. It's like in the case of auction sale. You go for an auction or to the auctioneers, then the purchaser is the one who pays the highest. So the same applies here with respect to the flotation forms. Offer by tender occurs where the company invites tenders for its shares and sells them to the highest bidder. This is done with a view of obtaining the best price possible for the shares. That's offer by tender. Next, we have discussed rights issue and bonus issue. We say that rights issue occurs where the issue of shares is made to the existing shareholders. You should note existing shareholders. For you to take advantage of rights issue, you should already be an existing shareholder. So issue of shares to the existing shareholder at a price below the prevailing market price, the price at which the shares or the securities are selling in the stock market. Rights issue is the issue of shares to the existing shareholders at a price usually below the prevailing market price. It occurs if a company which has been trading for some time makes an offer to the existing members to buy shares of a new issue in proportion to the number of shares they hold. It is the existing shareholders rather than the members of the public who are given the right to buy the shares. That's important point. That is, it is the existing shareholders who will enjoy this right rather than members of the public. So rights issue is not made to the members of the public. Rights issue is made to the existing shareholders so that they are given an opportunity to purchase these shares at a price, however, at a price below the prevailing market price. Whereas the members of the public are purchasing these shares in the stock market at a higher price, the existing shareholders are purchasing these shares at a price below the prevailing market price. This does not constitute to a discount. This is a rights issue. Issue of shares at a discount occurs where shares are issued at a price below the par value. And you say issue of shares at a discount in Kenya is not allowed. For it to happen, there are certain conditions which must be met. We did discuss that last lesson, chapter 4. Therefore, if you need more discussion about that area, just find out in our YouTube Fatima Institute and you can get that class there, chapter 4. Basically from chapter 1 all the way to chapter 5. And I think we'll be going through the entire company law within the next 2 or 3 weeks or so. Well, that is offer by tender. And lastly, so we have rights issue, that is the rights issue. And then last part was bonus issue. And we say bonus issue is an issue of shares to the existing shareholders for free. Right. So this is a method by which a company, instead of paying cash dividends to its members, retains the cash but issues new shares to the members. The total nominal value of the shares issued equals the retained cash. Now that explanation may be a little bit difficult for you, but just stick to this, the meaning of bonus issue. The issue of shares to the existing shareholders for free. So that is flotation, the process in which companies avail securities to the public for subscription. So a company wishes to raise capital from the members of the public. So what is supposed to happen? They use certain methods to raise capital from the members of the public. And this is called the flotation process. So they can either have direct offers, offers for sale, placing, offers by tender, rights issue, or bonus issue. So raising of share capital, and go through that. But first, you can go through that. You can go through that. Flotation. The flotation, raising of share capital. This is done through flotation. Flotation is a so flotation may take the following forms. One, direct offers, also known as invitation to the public or prospectus issue. You have offers for sale, placing, offers by tender, rights issue, and bonus issue. You just go through that. You can pause your video and you go through that. Offers for sale, placing, offer by tender, rights issue. I believe you have that. And the last portion was a bonus issue. However, bonus issue is not okay. Bonus issue, you know what we have said about bonus issue. Issue of shares to the existing shareholders for free. We move now to prospectus, also known as information memorandum. Now, prospectus is a notice, circular, or advertisement inviting the members of the public to purchase the shares of a company. It's just a Advertisement. Whenever a company wishes to issue shares to the members of the public, they will advertise this intention. It's like invitation to treat as it applies in the law of contract. That we are advertising as a company that there is a certain number of shares that we may wish the members of the public to purchase. That's a prospectus or information memorandum. Prospectus is a notice, circular, or advertisement inviting the members of the public to purchase the shares of the company. A private limited company is exempted from filing either a prospectus or a statement in lieu of prospectus, as it is prohibited from offering its shares to the public. Invitation or prospectus can only be issued by public limited companies. A private limited company cannot issue prospectus because these companies cannot issue their shares to the members of the public. A private limited company, as far as private limited companies are concerned, the transfer of shares is very limited. So to say that prospectus, also known as information memorandum, can only be issued by public limited company. So we are saying that a private limited company is exempted from filing either a prospectus or a statement in lieu of prospectus, as it is prohibited from offering its shares to the public. The issue of a prospectus is not to the public if there are certain circumstances under which the issue of prospectus will not be deemed to have been issued to the members of the public. And these are the issues. These are the circumstances. The issue of a prospectus is not to the public if, number one, it is directed to a specified person. If I issue a prospectus to a specific person, if a company issues a prospectus to a specific person, then that issue is not to the public. Number two, if it is not calculated to result into shares coming available to other persons. So we are issuing the prospectus. Our intention is that this prospectus, that information, will not be made available to other members of the public. Then that is not a prospectus to the public. And number three, if it is a domestic concern, prospectus which is issued to members of the family or family members, then that is not really a prospectus. Okay, next is circumstances in which a prospectus is not required to be issued. Circumstances in which a prospectus is not required to be issued. One, where the shares are not issued to the public but to a specific person. So if you are issuing prospectus to a specific person, or if the shares are going to a specific person, you don't need to issue prospectus. Number two, where the offer is made only to the existing members, e.g., in case of rights issue. So you are issuing shares to existing members, as in the rights issue. You say right issue occurs where shares are issued to the existing members at a price below the prevailing market price. So with the rights issue or bonus issue, we don't need to issue prospectus. The other situation in which we cannot issue prospectus is where the shares issued are in no respect uniform with the shares previously issued and quoted in the stock exchange. We issued shares of a certain type like preferred shares maybe last year, and then this year we are issuing the same shares which are similar, which are the same as compared to what we issued last year or previously. So in that case, we don't need to issue prospectus. So these are circumstances in which the prospectus is not required to be issued. Circumstances in which the prospectus is not required to be issued. From there, we have circumstances in which a company may issue a prospectus. Circumstances in which a company may issue prospectus. One, a newly formed company may issue prospectus inviting prospective investors to subscribe to their securities. That's one. If you have a new company which you have incorporated and you wish to invite members of the public to make subscription for these shares, then you should issue a prospectus. You say a prospectus is a circular, is a notice, is an advertisement issued by the company inviting the members of the public to subscribe to the shares of the company. So once a company has been incorporated for the first time, and mostly these are public limited companies, and this company wishes to raise shares, wishes to raise capital from the members of the public, then they should first start by issuing prospectus. They have to show the intention, the sort of invitation to trade, not a contract. In that case, as we will see later on, that prospectus is not a contract by itself, but invitation to trade. So the company should issue the prospectus to the members of the public, inviting them to make subscription to their share. So circumstances in which a company may issue prospectus. One, you say a newly formed company may issue prospectus inviting prospective investors to subscribe to their securities. Number two, an existing public company wishing to raise additional capital from the public may issue a prospectus in relation to the issue. So already an existing public limited company which wishes to raise additional funds, they have to issue prospectus to the members of the public. And lastly, number three, if a private company passes a special resolution converting itself into a public company, it ceases to be a private company from the resolution date and must within 14 days thereof deliver to the registrar the prospectus for registration. In addition to the prospectus, they must also deliver the statement in lieu of prospectus. I will discuss the statement in lieu of prospectus later on. Now, lastly, is the contents of prospectus. Simple area. What do you expect to be the contents? What do you expect to be the contents? The contents of prospectus. One, particulars of the directors, including their occupation. Number two, share qualification by the directors. Number three, remuneration of the directors. Number four, auditors of the company. Number five, remuneration of the promoters. Number six, preliminary expenses. Number seven, voting and class rights. Number eight, founders' shares, if any. Founders' shares, if any. Number nine, particulars of material contracts. Number 10, amounts payable on application and allotment of shares. Number 11, particulars of options on shares. 12 auditors report. So let me just show you that. Prospectus or information, memorandum the same name. I just go through that. Let's go through that. The first, prospectus, prospectus also known as information memorandum. You go through that. Pause your video. You look at the meaning of prospectus. The alternative name is information memorandum, and we are saying that prospectus is a notice, circular, or advertisement inviting the members of the public to purchase the shares of a company. Okay, the issue of a prospectus is not to the public if you have those 3 points there. From there, we look at circumstances in which a prospectus is not required to be issued, then circumstances in which a company may issue prospectus, and then the contents of prospectus up to number 8, and I will move to the other side. You have it, the other contents there. Then from there, we can now move to something else, and that is registration of the prospectus. Registration of the prospectus. Registration of the prospectus. Prospectus must be delivered to the registrar for registration on or before the publication date. Under section 43, subsection 3, the registrar may reject the prospectus if, number 1, it is undated. So a prospectus must have a date. If it does not have the date, then it will be rejected. Number 2, if it lacks the necessary endorsements. Number 3, if it is not signed as required by the Company Act. Okay, that is circumstances under which the prospectus may be rejected. It is a criminal offense to issue a prospectus before a copy thereof is delivered to the registrar for registration. It is a criminal offense to deliver to the registrar for registration a copy of the prospectus without the necessary endorsements. From there, we go to misrepresentation in a prospectus. Misrepresentation of the prospectus. Now, I believe you have done an introduction to law, and you know the vitiating elements in the law of contract. We have 4 major vitiating elements in the law of contract. One is misrepresentation, which we will be looking at in this subtopic. Misrepresentation is a vitiating element. The other vitiating element is duress. And number 3, undue influence. And number 4, mistake. Those are the four vitiating elements that we have done in law. That is the law of contract. The law of contract. The law of contract. We have certain vitiating elements. The law of contract. We have 4 vitiating elements. That is misrepresentation, the duress, undue influence, and then mistake. Now here, we look at misrepresentation in our prospectus. When you are getting into a contract, as you define in the law of contract, that a contract is an agreement between two or more people which is legally binding, there are certain statements that you make to the other party before you enter into this contract. Sometimes these statements may be wrong. These statements may be misleading. So you may have an intention to give misleading, wrong information to the other party so that you may induce this party into an agreement. Then afterwards, the other party, after the contract has been concluded, he or she comes to realize that the statements that you gave him or her prior to the contract were wrong, were misleading. So these statements which were wrong and were used by the other party to enter into the contract are what constitutes misrepresentation. For example, I'm selling to you a motor vehicle which you have not seen before. And then I may tell you that this motor vehicle is new, is a new brand motor vehicle. And then we enter into a contract and we agree that this is the offer price or this is the price to pay. But once I sell, when the vehicle now comes into your possession, you realize that this motor vehicle is not new. This motor vehicle is a second-hand motor vehicle. So in that case, there was a misrepresentation because I did not tell you in advance that this motor vehicle is a second-hand vehicle. I told you that this motor vehicle is a new vehicle. So you made a decision to get into this contract based on that information that you were to purchase a new motor vehicle. So we will look at the meaning of misrepresentation in prospectus. Remember here, we are talking about prospectus and particularly misrepresentation in prospectus. Remember, we have said that prospectus or information memorandum, the alternative name, is a circular, is a notice, is an advertisement issued by the company inviting the members of the public to subscribe to the shares of the company. So, to say it is an invitation to treat. So, if you are to make a decision to invest in a company, then that decision as a prospective investor is based on the information which is contained in the prospectus. For example, we may find in the prospectus that this company is very stable, it is making super normal profits, it has been paying dividends well, the company is financially stable. However, when you purchase the shares in this company, you come to realize that this company is in financial distress. This company is facing financial difficulties. This company does not pay dividends. This company has been operating at losses. The going concern of this company is impaired, is in doubt, and the company is at a very high risk of collapsing. So it means that whereas you made a decision to invest in this company based on misleading information, the information which comes later on is contrary to what you found in the prospectus, and therefore you were misled to make wrong investment decision because you made a decision to purchase those shares believing or in the belief that this is a stable company as you found the information in the prospectus, but the situation is the opposite of the truth. So misrepresentation in prospectus will imply the wrong information that you find in the prospectus, but after you make a decision to invest in this company, then the truth is not it's not really your expectations. The results or the truth, when the truth comes out, things are different from what you found in the prospectus. Okay, I will look at the meaning, the elements. We define misrepresentation is a false or untrue statement made in order to mislead the other party in order to enter into a contract. If the prospectus contains any false statement, this amounts to misrepresentation, and any person who will apply for the shares based on such misrepresentation can avoid the contract. That's misrepresentation in a prospectus. False or untrue statements made in order to mislead the other party, in order to enter into a contract. Because prospectus is an invitation, you are advertising, you are writing a circular or a notice to the members of the public, inviting them to invest or to buy shares in your company. So if there is a misrepresentation in the prospectus, you are telling them, because if you look at the contents of prospectus, you find things like auditor's report. What do you find in the auditor's report? You find statement of financial position, you find income statement, comprehensive income statements, you find the cash flow statements, statement of changes in equity. In this case, the auditor may have issued a what we call, I think we call that creative accounting sort of, or window dressing. Window dressing is a term that we use in auditing. Window dressing, whereby you show the company to be in a better position than it actually is. Window dressing. So if the auditor's report has been window dressed, the investor will make decision to invest in that company based on wrong information. The auditor is saying the company has been reporting profits, but in actual sense, it has been reporting losses. The auditor is saying the company is financially stable, but that is not the case. So in this case, you make a decision to invest in that company based on wrong information. So misrepresentation is a false or untrue statement made in order to mislead the other party in order to enter into a contract. If the prospectus contains any false statement, this amounts to misrepresentation, and any person who will apply for the shares based on such misrepresentation can avoid the contract. Elements of misrepresentation. Elements of misrepresentation. 1. The statement must be false. Number 2. The statement was a statement of fact and not a statement of law or a mere expression of an opinion. We are talking about statement of fact. Now, in philosophy, we usually say that a statement can be that of fact or tautology. Now, a tautology is that statement which does not need further explanation. Like, for example, you say, uh, your sister is a girl, or you say your mother is a woman, or your father is a man. It does not make sense. We are talking about the same thing. You can say that your mother is a woman. So once you say mother, we obviously know we do not have male mothers. If you say your father is a man, we know you do not have female fathers. So tautology, a statement can either be a tautology or a statement of fact. A statement of fact is a statement which can be evidenced, which can be proved by evidence. If you say it is raining, you can you just check from outside whether it is raining or not, because it can either be raining or not raining. So when you say it is raining, that statement can be proved by checking for yourself from outside. So a statement of fact is that statement which can be proved by evidence. You can check for yourself. Now, in philosophy, we say that a statement can either be tautology, a statement of tautology, or statement of fact. And a statement which is neither a tautology nor a statement of fact is useless. Is useless. A useless statement is that statement which can neither be classified as a tautology or statement of fact. That's philosophy, but we are not doing philosophy. We are saying that some elements of misrepresentation. One, the statement must be false. The statement was a statement of fact and not a statement of law or a mere expression of an opinion. Number three, the statement was made before or during the time of entering into the contract. So misrepresentations should have been made before the contract or during the process. This statement should not have been made after. Okay, number four, the statement was intended to induce the other party to enter into the contract. So for it to be called a misrepresentation, the intention should have been made with the purpose of inducing the other party to enter into a contract. Number five, the other party relied on this opinion and entered into the contract. The other party relied on that opinion. Now we look at types of misrepresentation, and we have three of them. One, innocent misrepresentation. Number two, negligent misrepresentation. And number three, fraudulent misrepresentation. Okay, I want to look at innocent misrepresentation. This is a true statement made innocently with honest belief in its truth and without intention to deceive. It arises in circumstances where directors who anticipate the occurrence of a particular event makes a binding statement in the prospectus based on such anticipation only to be disappointed later when what was anticipated fails to occur. That's innocent misrepresentation. The directors have made certain anticipation, and when inviting the members of the public, they invite them based on this particular anticipation that at a certain time in the future, this is what we expect to happen. If, for example, it is information based on uh, projections, maybe sales projections or profit projections, and you include that information in the prospectus, you are telling the prospective investors that this company is expected to report more profits, more sales, more cash flows. But because this information is based on projections, that does not occur. That is an innocent misrepresentation, even though the information is misleading, but it was not the uh, it is not it was not the intention. It was not the intention of the directors to issue this misleading information. It's like, for example, I'm selling to you a certain asset, and we agree. However, that asset has been stolen or has been destroyed by fire. Obviously, I'm not aware that the asset has been stolen or that asset has been destroyed by fire. So, even though this information is wrong, is misleading, I have not really. It is not in my mind that I'm planning to issue you with wrong information. I'm innocent because I'm not aware of that fact. So innocent misrepresentation. Number two is negligent misrepresentation. This is a true statement made recklessly or negligently, without intention to deceive, but without taking due care to verify the truth, even though the maker of the statement is an expert, e.g., an auditor. So when you talk of Negligent misrepresentation, it arises where the person involved is a professional, but this professional does not take due care. Like, for example, an auditor issues misleading audit report. An auditor should act professionally, must observe due care, must have in mind the effect on the users of the information that he issues. If the auditor does not put that into consideration, if the auditor does not put that into account, then the users or the third parties who will make use of that information may end up incurring financial losses or making wrong investment decisions. That's what we call negligent misrepresentation. For negligent misrepresentation, there has to be a professional who is not taking due care. Lastly, fraudulent misrepresentation. This is a false statement made knowingly and deliberately with an intention to deceive and without honest belief in its truth. So that is just made knowingly. It's like conmanship. It's like a conman. You know what you are doing. It's a fraud. That's fraudulent misrepresentation. So you should check misrepresentation in a prospectus. Misrepresentation in a prospectus, what you should check now, if you have not gotten it right. Misrepresentation. Misrepresentation. You have misrepresentation in a prospectus. You can check that. Misrepresentation is a false or untrue statement made in order to mislead the other party, in order to enter into a contract. If the prospectus contains any false statement, this amounts to misrepresentation. And any person who will apply for the shares based on such misrepresentation can avoid the contract. So we have elements of misrepresentation. We have 5 of them here. You can go through these elements of misrepresentation. Types of misrepresentation: we have innocent misrepresentation, we have negligent misrepresentation, and we have fraudulent. We have fraudulent misrepresentation. You have fraudulent misrepresentation. I go to remedies for misrepresentation. The remedies: civil remedies against the company. We have recession. We have civil remedies against the directors. So if you're looking at remedies for misrepresentation in prospectus, you have civil remedies against the company. One is rescission. Civil remedies against the directors, we have damages for deceit, the damages for negligence and the common law. Let me first of all go through these remedies. We are saying that a company has issued prospectus which contains misleading information. You have suffered a loss. You have suffered damages as an investor. How will you compensate that particular person? Either the company or the directors themselves. Remedies for misrepresentation in prospectus. You have civil remedies against the company. One is rescission, where the allotee gives back the shares and recovers the amount paid on application. So if you have invested in a company based on wrong information, then you can refund, you can return the shares back to the company, and the company refunds back your money. That's a rescission. Rescission is a remedy, it's a civil remedy which is against the company. So the allotee gives back the shares and recovers the amount paid on application. He must, however, prove three things. So for this to happen, for this to succeed, for this particular remedy to succeed, for rescission to succeed, then the affected party must prove these three things. One, the statement was false, that is the statement which he relied on to invest in these shares. That is not misrepresentation. We have seen some elements of misrepresentation. In other words, the statement must be false. Because if a statement is true, then it can be classified as misrepresentation. So the statement was false. Number two, the statement was one of the facts. And number three, the statement was addressed to him. So specifically that person who is claiming to have incurred financial losses or damages, he or she must prove that this particular statement was made to him or her. So three things to prove for that remedy, uh, for, for that to succeed, rescission, when you are making that particular claim, that is the statement was false, the statement was one of the facts, and the statement was addressed to him. Rescission is an equitable remedy and may be lost if, so these are circumstances under which you can lose the remedy for rescission. One, the plaintiff sells all or part of the shares. So you have purchased the shares and then you sell all of them or part of them, you cannot claim for that particular remedy for rescission. Number two, if he fails to act within a reasonable period. Number three, if he fails to act on discovery of the fund. So you will lose that equitable remedy of rescission if those three conditions arise. That is, the plaintiff sells all or part of the shares, if he fails to act within a reasonable period, if he fails to act on discovery of the fund. So that's one civil remedy against the company with respect to misrepresentation in prospectus. So we have said the rescission. Number two, damages for deceit. And number three, damages for negligence under the common law. We look at civil remedies against the director. So what we have is civil remedies against the company. You see the rescission. Number two, damages for deceit. And number three, damages for negligence under the common law. I go to civil remedies against the directors. One, damages for deceit. An allotee may sue the directors if he can prove that one, that the statement was false. Number two, the statement was one of the facts. Number three, the statement was addressed to him. Number four, he was induced by the false statement to enter into the contract. The directors are responsible because it is by their resolution at their board of directors meeting and with their approval that the prospectus is issued. However, a director can escape liability if he can prove the following. So what we are discussing here is an investor who relied on wrong information as contained in the prospectus, and he or she has incurred losses or damages and is seeking for compensation. Responsibility on the side of the company, responsibility on the side of the director. So here we are saying, if that is the case, then how can the director escape liability? One, he did not take part in the BOD which authorized the issue of the prospectus. In that case, the director will not be liable. He's saying, in that board of directors meeting, Authorizing this prospectus, I was absent. In that case, the director will not be liable. Number two, he did not agree with his fellow directors on the issue of the prospectus. So this particular director is saying that it is true that this particular prospectus contained misrepresentation or a vitiating element. However, I disagreed from the start. I did not agree with the issue or this matter, which resulted to this prospectus having misrepresentation. So if he did not agree with his fellow directors on the issue of the prospectus. Number three, he recorded his disagreement with the other directors with respect to his disagreement. So in those situations, the director will not be liable. So I'll present that one to you. Civil remedies against the company and civil remedies against the directors. Check that. Check remedies for misrepresentation. In prospectus, we have civil remedies against the company. Check recession, damages, and damages for negligence under the common law. However, there are additional norms concerning rescission. So civil remedies against the company, civil remedies against the company. Then we have civil remedies against the directors. Civil remedies against the directors. We have damages for deceit. And the rest here, you pause your video and you go through that. I'll look at damages for negligence under common law. Directors are held liable to pay damages for misleading the members of the public. Directors are liable to pay damages for misleading the members of the public. An allotee can recover compensation from a director or a promoter for any loss he sustained in reliance with any untrue statement in the prospectus. If you are making investment decision, if you want to purchase shares of a company, obviously you got that information from the prospectus. However, if that information was wrong, either it was fraudulent misrepresentation, either it was innocent misrepresentation, or whatever it was, then you can sue the company, and the company or the directors will be required to make a compensation of the equivalent of what you've lost. You have defenses available to directors and promoters. In this case, you have made a decision based on misrepresentation, because most of these decisions are made by board of directors and promoters or the shareholders, the promoters specifically, where the company is coming into operation for the first time. So what defense is now? How can the directors defend themselves? How will they escape liability now that you are saying you made an investment decision based on misrepresentation, based on wrong information in the prospectus? How will the directors defend themselves? One, that he was reasonable, that he had a reasonable belief that the statement was true. That's a defense to the director. If he says that that information in the prospectus, I was 100% sure that the statement was true. That's a defense. Number two, that the statement was authorized by an expert. who you reasonably believe to be competent, and use that one as a defense as a director, especially where that information came through a profession. So the director is saying that the information was made or was prepared by a competent profession. And that is why I believed that information in the prospectus number 3, that the consent to act as a director was withdrawn before the issue, and the prospectus was issued without his consent. So simply, as a defense, the director is saying that that prospectus was issued without his consent. So he has nothing to do with that information. Number 4, that he gave a reasonable notice that the prospectus was issued without his consent. Such notice must be issued to the registrar of the company. Number 5, that he withdrew his consent and gave a reasonable public notice after the issue of the prospectus, but before the allotment of the shares. I move to civil remedies against the expert. Now, the expert here can be an auditor, for example, or investment consultant. Civil remedies against the expert. 1, damages for deceit, and 2, damages for negligence. Civil liability. A third party who has suffered a loss or damages by reason of subscribing for the shares or debentures of a company, or the faith of the prospectus containing an true statement, is entitled for compensation for the loss or damage by 1, every person who was the director of the company at the time of the issue. Number 2, every person who was a promoter of the company. Number 3, every person who had authorized him to be named in the prospectus as a director and who and was so named. Number 4, every person who had agreed to become a director of the company either immediately or after a few days later. Number 5, every person who authorized the issue of the prospectus. So I just checked defenses available to directors and promoters. Remember, these defenses are arising because an investor has made a decision to invest in a company based on wrong information as contained in the prospectus. So, what defense is available to either directors or promoters? In chapter 1, we did promoters, and we said a promoter is that person who comes out with the idea of starting a company and how the affairs of the company will run. So, defense is available to directors and promoters. Directors are coming in because company decisions are made by board of directors. There are those decisions which are delegated. Remember, the companies, the owners of the company are the shareholders, what we refer to as members in chapter 3. So, shareholders are the owners of the company, but there are certain duties and functions which are delegated to the directors. So some of these decisions which are made by the directors, sometimes there may arise a situation where these directors should be held personally liable because maybe the information was wrong, the information was misleading, or this information contains some aspects of misrepresentation, either innocently or fraudulently. You can just check defenses available to directors and promoters and civil liability before I take up statement in lieu of prospectus. Alright, so you can see defenses available to directors and promoters. Defenses available to directors and promoters. 1 to 5, then civil remedies against the expert. You have damages for deceit, damages for negligence, Then civil liability, I check that and then we go to statement in lieu of prospectus. Statement in lieu means in place of. Statement in lieu of prospectus, and we have said in lieu means in place of. So in lieu means in place of. Statement in lieu of prospectus is prepared and issued by public limited companies in certain circumstances, either in place of or in addition to an ordinary prospectus, inviting for members of the public to subscribe for the shares or debentures of the company. You have contents. Contents of statement in lieu of prospectus. You have nominal share capital, names and particulars of the directors, voting rights, debentures issued, particulars of any material contracts, the auditor's report. Okay, how this is the contents of statement in lieu of prospectus. Most of them are not different from the contents of prospectus. These are the contents here. Contents of statement in lieu of prospectus. Nominal share capital or this. There may be others. Statement in lieu of prospectus. Move away from there. You have told circumstances when a company may issue a statement in lieu of prospectus. Circumstances under which a company may issue a statement in lieu of prospectus. You have one and two. Circumstances under which a company may issue a statement in lieu of prospectus. We have one and two. We have when a private company goes public, when a private company changes from being private to public, then it has to issue statement in lieu of prospectus, where a public limited company have privately arranged for its public subscription. It must issue a statement in lieu of prospectus, which the registrar must receive within 3 days before the allotment of the shares. I move to maintenance and alteration of share capital. I move to maintenance, and alteration of share capital. I take alteration of share capital. This entails, I'm looking at alteration of share capital. Uh, this entails changing the capital clause of the company's memorandum of association. It is an increase, reduction, or any other change in the authorized share capital of a company. Share capital may be altered in the following ways. Now remember, when you talk of alteration of share capital, remember in the memorandum of association, you have the capital clause. Now, anything which entails increasing the same, reducing the same, or change in the same constitutes alteration of share capital. So basically, alteration of share capital entails changing the capital clause of the company's memorandum of association. It is an increase, reduction, or any other change in the authorized share capital of the company. Share capital may be altered in the following ways. One, redemption of redeemable preferred shares, increase in share capital, conversion of shares into stock, reconversion of stocks to shares, subdivision of shares. Then consolidation of shares, diminution of capital, reduction of share capital. So redemption, let's look at the ways in which uh, alteration of share capital may occur. They're saying one is redemption of redeemable preferred shares. We did types of preferred shares, and you said can have redeemable preferred shares. To redeem means to purchase back. Redeemable preferred shares are those shares issued by the company. However, the company can purchase them back in the future. Now, if we purchase back those shares again, the implication is that the capital side now will increase. Our shares will increase because we have taken back our shares now from that particular shareholder. So redemption of redeemable preferred shares. This is where shares which were issued as redeemable are purchased back in the future. Shares once purchased back will increase the share capital of the company. Redemption of redeemable preferred shares is governed by the following rules. One, it must be authorized by the articles. Shares must be redeemed out of profit. Premium must be fully paid. Premium payable must be provided out of profit. Redemption must be passed by an ordinary resolution. Notice of the redemption must be delivered to the registrar within that days. So that's redemption of redeemable preferred shares. Number two, increase in share capital. This entails the issue of new shares by the company if the article permits the same. So issue of new shares can result to alteration. Conversion of shares into stock. So you have shares, you convert them into stock, therefore your shares are reducing. So if shares are converted into stock, the share capital will reduce. This must be passed by an ordinary resolution, and the articles of the company must permit the same. The registrar must be notified within that days. So that is conversion of shares into stock. So once you convert shares into stock, your share capital reduces. Then number next, reconversion of stocks to shares. The other way around. If you have stocks, convert the stock into shares, your shares now will increase. Reconversion of shares, reconversion of stock to shares. This will increase the share capital. This must be passed by an ordinary resolution, and the articles of the company must permit the same. The registrar must be notified within that days. Then subdivision of shares. This is like a share split. If you do the share split, your shares will be increasing. So share split, we have, and we are saying that this is splitting shares into small units to make them more affordable. It is called share split or the script issue. For example, one share with a par value of shillings 50 may be split into two. Hence, you will have two shares with a par value of shillings 25. Share split will increase the number of shares. This must be passed by an ordinary resolution, and the articles of the company must permit the same. The registrar must be notified within that days. The other is consolidation of shares. Now it's the opposite of share split. If you do the share split, your shares are increasing. If you have one share, you split it into two, then there are two shares. If you consolidate them, there will be one. So the opposite of share split is share consolidation. So consolidation of shares. This is the opposite of share split. It involves combining of shares to form one large share whose nominal value is the aggregate of the shares consolidated. It reduces the number of shares. This must be passed by an ordinary resolution, and the articles of the company must permit the same. The registrar must be notified within that days. Next is diminution of capital. This is the cancellation of the whole or any part of the unissued shares of the company. This must be passed by an ordinary resolution, and the articles of the company must permit the same. The registrar must be notified within that days. So diminution, again, will alter the share capital. And lastly, reduction of share capital. The general rule is that it is illegal for a company to reduce its capital. This is because such a reduction is tantamount to reducing the security available to the creditors of the company. However, a company limited by shares of guarantee may reduce its capital in the following circumstances. One, if the reduction is authorized by the articles of the company. Number two, if the reduction is passed through an ordinary resolution. Number three, if there is an application made to the court and the court allows a reduction. So that's a alteration of share capital. I just go through that. If you didn't get ending, you didn't get ending there. You can just go through that. This is maintenance and alteration of share capital. Alteration of share capital can be done through redemption of redeemable preferred shares, increase in share capital, conversion of shares into stock, reconversion of shares to shares, subdivision of shares. This is known as a share split. The share split, move on to the other. So this explains the share split. This explains the share split. This explains the share split, the explanation for share split, then consolidation of shares, diminution of capital, reduction of share capital. So those are the ways in which you can do alteration of share capital. So I will move to dividends. The simple area now, which is to do with the dividends. We know what dividends are. Once you invest in a company, because you have provided the company with your resources, with your money, you are the investor, you are the shareholder, the company has to appreciate, must compensate, must pay you dividends. Now let's look at dividends. This is the return on the investments of a member. This is actually what a shareholder is paying for investing his money in the company in form of shares. Dividends may be paid mid-year, that is interim dividends, or by the end of the year, that is final dividends. So dividends can either be interim dividends or final dividends. Let me look at rules which govern the payment of dividends. Rules which govern the payment of dividends. These are the rules which govern the payment of dividends. One, let's have the rules which govern the payment of dividends. One, the directors recommend the dividends and the members declare the same in the AGM. The members mean shareholders. So what happens is that the directors will recommend the dividends. If the board of directors recommend dividends worth 1 billion, then the shareholders should declare the same figure on the AGM or during the annual general meeting. There can be two dividends here. So whatever the directors have recommended is the same amount which the shareholders should declare. That's the meaning of that particular point. It's the rule. It's the first rule which governs the payment of dividends. That is, the directors recommend the dividends and the members declare the same in the annual general meeting. Members mean shareholders. Number two, a company cannot pay dividends if it will result to its inability to pay debts. You can't pay dividends so that by so doing, the company has no resources to pay debts. What comes first is ability to pay debts. If the company has no ability to pay debts, then it cannot pay dividends. Because dividends are going to the owners, a debtor is not part of the ownership of the company. So you cannot transfer the risk from the owners to the debt providers. So if a company has no capacity to pay debts, then it should not declare dividends. Simply, a company cannot pay dividends if it will result to its inability to pay its debts. Number three, directors may from time to time pay members such interim dividends as is justified by the profit of the company. So from time to time, we are saying you can pay interim dividends, that is by the middle of the year. So it depends with the profitability of the company. If the company is performing well, then from time to time, it is upon the board of directors uh, to recommend the dividends which should be paid to the shareholders by the middle of the year. So directors may from time to time pay members. When I talk of members, I mean shareholders. Directors may from time to time pay members such interim dividends as is justified by the profit of the company. Number four, the general meeting cannot declare dividends in excess of the amount recommended by the director. Simply, that is, the shareholders cannot recommend or declare a different figure from that which was recommended by the board of directors. It's the same as point number one, whereby we have seen the directors recommend the dividends and the members declare the same in the annual general meeting. If you look at point number one. And point number four, we are saying the general meeting cannot declare dividends in excess of the amount recommended by the director. So the directors recommend the dividends, the shareholders declare the dividends. Number five, no dividends shall be payable otherwise than out of profit. So you pay all dividends out of profit. You can pay it out of loans. You can get a loan to pay dividends. You can sell assets to pay dividends because a dividend is profit appropriation of profit. So all dividends should be paid out of profit. Number six, directors are empowered to deduct from the members' dividends any amount due to the company, e.g., calls in arrears. So if shareholders owe the company any amount, for example, shares or maybe some outstanding figure with respect to shares, before they pay these shareholders, directors should first deduct those arrears or those owings from the dividends, and then they will pay the shareholder the net figure, what remains. So we are saying directors are empowered to deduct from the members' dividends any amount due to the company, e.g., calls in arrears. Number seven, directors are empowered to put into the reserve such portion of the company's profit which they deem prudent not to distribute. It is not necessarily, it's not a must to distribute all the profit after tax as dividends. So it is upon the directors to make prudent financial decisions to distribute part of the profit after tax as dividends and retain another figure for the purpose of maybe the expansion of the company in the future. So directors are empowered to put into the reserve such portion of the company's profit which they deem prudent not to distribute. Number 8, dividends may be paid in cash or by check. Number 9, dividends are generally payable within 42 days of its declaration. So once you declare dividends today, then such dividends should be paid within 42 days. Circumstances when dividends may become payable and enforceable as a debt against a company. Basically, no dividends may be paid otherwise than out of profit. Dividends are payable after the payment of all the debts and liabilities incurred during the year. Dividends are only enforceable after declaration. Until dividends have been declared, a shareholder cannot enforce its payment, even though the company may be making huge profits. However, once declared, dividends will become a debt due from the company to each shareholder, the recovery for which he can sue the company. An interim dividend is not a debt, and the directors can decide it by resolution. The company may seek to control the funds from which dividends are payable for such reasons such as to maintain a certain level of reserves or to facilitate maintenance of capital. So I'll take you through dividends now. Understand rules which govern the payment of dividends. Rules which can check what dividends are. Looking at dividends, you can pause your video, go through rules which govern the payment of dividends. Rules which govern the payment of dividends. Rules which govern the payment of dividends. You have 1 up to 6. Rules are there. You just pause your video and you understand that, and then finish up from 7 and up to 9. These are rules which govern payment of dividends. Then you can read this particular portion. Away from that, I'll look at the purchase by a company of its own shares. You have the rule in Trevor versus Whiteworth. Now, we think that there are certain specific case laws in each chapter in company law. In chapter 1, we said you look at the case in Salmon versus Salmon, which explains the concept of separate legal entity. Look at the case in Ashbury versus Richard. Which explains the doctrine of ultra-bias. Look at the case in Makaura versus Northern Assurance. Also explains the concept of separate legal entity. Look at the case in Bamboo Press, which explains the concept of takeover bid. We also have the case in Force versus Haboto. The case in Force versus Haboto. And then now, in this chapter, we've come across another case known as the rule in Trevor versus Whiteworth. This important case for the purpose of company law. Now, our subtopic here is the purchase by a company of its own shares. Can a company purchase its own shares? That's the question. Now, it's like this. A company advances money to you and you purchase shares in the same company. Is it applicable? Is it applicable for a company to purchase its own shares? That is the question. Now, like this situation, you go to Kenya Commercial Bank, you borrow money from Kenya Commercial Bank, go to Nairobi Securities Exchange, and you purchase shares belonging to Kenya Commercial Bank. Even though you look at this as an exemption now, but is it a normal? Is it something which is ordinarily acceptable? You know that to be an exemption. Is it allowed for a company to purchase its own shares through its own members or shareholders? So the purchase by a company of its own shares, where the case study here is that of Trevor versus Whiteworth. Now, as a general rule, a company may not, by means of a loan, guarantee, or provision of a security, directly or indirectly provide financial assistance for the purchase by any person the shares in the company, or where the companies are subsidiary in the holding company. The rule in Trevor versus Whiteworth states that a company cannot purchase its own shares. However, there are various exemptions to this rule, which include. Now, the examiner may ask you, state the rule in Trevor versus Whiteworth. Then after that, state exemptions to this rule. So the rule in Trevor versus Whiteworth states that a company cannot purchase its own shares. The rule in Trevor versus Whiteworth states that a company cannot purchase its own shares. However, there are exceptions to that. What are the exemptions to the rule in Trevor versus Whiteworth? 1. The lending of money is part of the ordinary business of the company, and the same is lent by the company in the ordinary course of the business. It becomes acceptable, like the situation of bonds. A company, whereas we are saying, according to the rule in Trevor versus Whiteworth, a company cannot finance the purchase of its own shares if that company, it is the ordinary business of that company to lend money, then it becomes acceptable, as it is the situation or the case with commercial banks. You can get loan from commercial bank, then you go to the stock market, you purchase the shares of the same commercial bank, because no one will ask you, or no one will know where you got this money from. No one will ask you, or no one will know where you got that money from. Even though it has originated from the same commercial bank, you can use it to purchase the shares of the same commercial bank. So that is one exemption to the rule in Trevor versus Whiteworth. That is, the lending of money is part of the ordinary business of the company, and the same is lent by the company in the ordinary course of the business. Number 2, exemption number 2 to the case in Trevor versus Whiteworth. If the company has enforced a scheme to advance loans to its bona fide employees other than the directors to enable them purchase its fully paid up shares as a way of beneficial ownership. That is, we have a scheme. This company has a scheme to advance loans to its bona fide employees other than the directors to enable them purchase its fully paid up shares as a way of beneficial ownership. If that scheme does exist in that particular company. And number three, if the company has enforced a scheme to advance loans to trustees to enable them purchase its own fully paid up shares for the benefit of all its employees, including salaried directors. And lastly, effects of financial assistance for the purchase of its own shares. Effects of financial assistance for the purchase of its own shares. One, the company and every officer responsible will have committed a criminal offense and will be liable for a fine. So basically, we are saying that a company cannot advance loan to its members to purchase its own shares. Or simply, a company cannot purchase its own shares. What are the legal consequences in those situations where the company through its directors is purchasing its own shares? So, effect number one, the company and every officer responsible will have committed a criminal offense and will be liable for a fine. Number two, if the company had lent money to finance the purchase of its shares, it can recover the loan. Number three, any debenture or other security in connection with financial assistance is invalid. Number four, the agreement to purchase the shares is unenforceable. Number five, the company may sue its directors for the breach of duty to recover any loss for the breach. Number six, the directors are liable for damages for the breach of trust. So that is it about the purchase by a company of its own shares, and that is specifically explained through the rule in Trevor versus whiteworth. That's very important case. I'll be giving you the specific cases in company law which you need to understand. As far as case law is concerned, there are billions and billions of case laws as far as commercial law is concerned. So you need the specific case laws as far as company law is concerned, which you should concentrate on. And that is where I'm telling you that so far, I've told you to check the case in Salmon versus Salmon, the case in Makaura versus Northern Assurance Company Limited, the case in Ashbury versus Richard, the case in Bango Press, the case in Force versus Amberton, and now you have the rule in Trevor versus Whiteworth. These are the cases now which are specific as far as company law is concerned. You can just go through the purchase by company of its own shares, understand that the rule in Trevor versus Whiteworth requires that a company cannot purchase its own shares, understand the circumstances under which a company may purchase its own shares, that is exemptions to the rule in Trevor versus Whiteworth, and then the effects of a company purchasing its own shares. What are the effects, or what are the consequences which will arise if a company has purchased its own shares? So, as we conclude, you can just go through that. That is the purchase by a company, of its own shares, the purchase by a company of its own shares. We have the rule in Trevor versus Whiteworth. Then these three are exemptions. These 3 points, they are exemptions to the rule in Trevor versus Whiteworth. And then effects of financial assistance for the purchase of its own shares. So that means the legal consequences or the effects. What will happen to the directors or the promoters or the officials who are assisting the company to purchase its own shares. So you have these 1 up to 4, and then you turn now to the next page where you wind up, the effects there. Okay, maybe even though I'll be coming back to revision, can just check these past papers. Can just go through the few questions here. My number is here 072787 1093 072787 1093. Okay, we have but I think we've come to the end of that particular chapter. Remind you what is expected of you as far as chapter 5 is concerned: meaning and types of share capital, raising of share capital, prospectus or information memorandum, maintenance of capital, alteration and consolidation of share capital, and then you have dividends. That is what you expected to study. So far we have covered chapter 1, chapter 2, chapter 3, chapter 4, and now chapter 5. Next time we'll be moving to chapter 6, and that will be debt capital. We will be moving to debt capital. So chapter 1 we have done nature and classification of companies. Chapter 2 we did formation of companies. Chapter 3 membership of a company. Chapter 4 shares. And chapter 5 the share capital. So next lesson we'll be moving to debt capital. Next time we'll be moving to debt capital. And this is what we have already covered. So this is your syllabus, is paper number 7, company law, intermediate. So we have nature and classification of companies. We have done that. We also done chapter 2, formation of companies. We've done chapter 3, membership of a company. Chapter 4, shares, which continues that side, shares. Then we have done share capital as our chapter 5. We'll be moving to debt capital. Next lesson is debt capital. We'll be taking borrowing powers of a company, then company assets that can secure a company's borrowings, company debentures, company chances, meetings and resolutions in respect of debt capital, registration of chances, remedies for debenture holders. So chapter 6, we will be moving to debt capital. So prepare for that, and because that will be our next lesson. So we stop at that. Remember to subscribe to our YouTube channel so that you may continue to get these classes as and when we upload them. My name is Mr. Williams of Fatima Training Institute, Center for CIFA Studies. We have branded ourselves as a Center for CIFA Studies, not necessarily because we deal with CIFA alone, but we also deal with other areas like if you are doing CIFA, we have a good book here. We also do CIFA. That is our major specialization. We are specialized in certified investments and financial analysis. So this is a good book for fixed income investments analysis. So any subject that you may need, you can have all these CIFA books for foundation, intermediate, advanced level. So we are not saying that because you may be asking why. The reason as to why we call ourselves Center for CIFA Studies is because uh, most of the times we are experts in investment financial analysis. We are much. This is professional ethics and governance for foundation. We are much into CIFA, but we also have 8D. We also have some. We also take 8D. It's principles of auditing. So we are not limited to one area. So this was a CPA, intermediate, company law, paper number 7. We stop at that. We continue from there. So subscribe, like our video. If you need any assistance, my numbers are 07 27 87 10 93. We stop at that. We pick from chapter 6. Thank you.